Did you know that decades ago, the European Council passed a resolution that said that EU law should be drafted in plain language? We know the benefits of drafting in plain language. Primarily, you create a text which is then accessible to the reader, so the reader then understands the law that they are subject to. And we also know that drafting in plain language means that you draft in an unambiguous, precise way, which is great for you as a drafter. It's great for you. It's great for the readers who then have to read the law, who are subject to that law. Everything is great, right? Well, the question is EU law drafted in line with plain language principles? Because if it is, there shouldn't be any ambiguity, right? Let's find out. So as you can see behind me, this is the European Council resolution of June 1993, which sets out how the European Union should be drafting in order to ensure that they are drafting in plain language and improve the quality of drafting of community legislation. The link to the document is up here on the screen, and it's in the video description below, so please click on the link, download the PDF and read through it. It really is quite interesting. For today's video, I want to focus on two issues. In point number 1, it says the wording of the act should be clear, simple, concise and unambiguous. In point number 4, it says the rights and obligations of those to whom the act is to apply should be clearly defined. So if someone has to do something, it should be very clearly defined who it is and what it is they have to do. And it should be written in an unambiguous way. Now we've got this document, which was published in 2015. As you can see here, it's the EU's Joint Practical Guide of the European Parliament, the Council and the Commission for persons involved in the drafting of the European Union's legislation. Once again, the link is up here on the screen and it's in the video description below. And once again, I would recommend that you download the document and read through it. Some interesting stuff. For today's video, I want to focus on point 1.1. The drafting of a legal act must be clear, easy to understand and unambiguous, and it must be precise, leaving no uncertainty in the mind of the reader. I think you know where I am going with this. Are these pieces of guidance actually being applied in drafting EU legislation? Plain language, remember, it's not just a set of rules that tells you how to draft a document so someone can find what they need, they can understand what they find, and then they can use what they can find. Clearly, that is the aim of plain language, but plain language is also about identifying errors through the editing process, which identifies the language which creates that ambiguity in the first place, which is very often what happens in the first draft. You draft in a certain way, you employ all kinds of bad habits, as we all tend to do in terms of drafting. Then you go through the drafting process, you identify those things, you redraft them, and then you have a much improved final document. One of those things that is really essential to identify is an issue that we call an unclear antecedent or an unclear antecedent. Antecedent, I think, is the way that you say this. This is fundamentally important because if you don't identify this and redraft this in your legal documents, what you are doing is you are introducing not only ambiguity, but you're giving the reader the opportunity to interpret the text how they see fit. Now, clearly, that's not good, giving the reader the possibility to do that. As legal drafters, we should be writing in ways which are clear, precise, and ambiguous, so our writing cannot be interpreted in any way that the reader might see fit. So I want you to have a look at this here. Now, we've got the resolution, which was 1993. We've got the guidance, which was in 2015. And then we've got this directive about cybersecurity, which is from December 2022. Now, I'm going to skip over, in this little section, I'm going to skip over the bits which clearly don't follow plain language drafting, the use of shall, the use of legal prepositional phrases, nominalizations, etc., to get to the main point of this, which is the unclear antecedent. So let's just skip down to, and let's read it out for context. Member states shall ensure that for the purpose of notification under paragraph 1, the entities concerned submit to the CSIRT or, where applicable, the competent authority. Point B, without undue delay, in any event within 72 hours of becoming aware of the significant event and incident notification, which, where applicable, shall update the information referred to in point A. Okay, and now we're getting to the unclear antecedent. And indicate an initial assessment of the significant event. So we've got two things here. We've got an initial assessment and we've got a significant event. What follows? Including its severity and impact. It. I'm going to highlight it here. What does it refer to? Does it refer to significant incident, or does it refer to an initial assessment? We don't know. Severity and impact. If we carry on reading, it says its severity and impact. Well, an assessment can have a severity and it can have an impact. A significant incident can have severity, can have an impact. So that doesn't help us in understanding either. So what does it refer to? The answer is we don't know. And that is an unclear antecedent. It means that the reader has got to try and work out for themselves. They've got to interpret this and try to make sense of it. Now, in an ideal world, the reader would get in contact with the legislator and say to the legislator, what exactly do you mean by this? But that's not always practical or possible, which means that effectively what we've got is poor drafting, which doesn't follow plain language principles, which gives the reader a problem in terms of understanding. Okay? I've done lots of videos on unclear antecedents in the past. As it says here, as you can see, it confuses judges and everyone else. There is no convention in the English language which tells us how to understand unclear antecedents. There is an approach, and I'll talk about that later on in this video, and I'm going to call it an approach because I don't think it's nowhere near a rule, and there's no unanimity on accepting this approach. Certainly I do not, and certainly my experience of having known this area of plain language and read case notes which are based on unclear antecedents, this approach clearly doesn't apply in legal practice, but nevertheless it exists. But as I said, we'll talk about that later on in the video. But in short, there is no convention which tells us that if we meet an unclear antecedent in the English language, we have to understand it in this way. Now, in other languages, there may well be those conventions, but in the English language, there is not. Let's move on onto this text here. Now, I'm going to shrink myself down to the corner here because I know that there's my shoulder is going to block some text in a few moments. Now, this text is particularly relevant, and indeed it was the reason why this video was created, because someone asked me about this specific piece of text, which I think was found in Annex 1, and they wanted to know who is being affected or how should we understand this text, and they highlighted the issue. Let me read through this. Operators of a recharging point that are responsible for the management and operation of a recharging point which provides a recharging service to end users. So that's a non-defining relative clause there, particularly with which, including in the name of and on behalf of a mobility service provider. And you might think on first glance there's not that much wrong with that sentence, but there's a plenty wrong with that sentence. First of all, we've got the unclear antecedent, which is which, or that whole phrase really. Who are we talking about here? Who does which refer to? Does which refer to a recharging point, or does which refer to an operator? This is another unclear antecedent. And once again, when the person asked, who are we talking about? Are we talking about the operator, or are we talking about the recharging point? My answer was the truthful answer, which is, I don't know, because there is a legal drafting error here which prevents us from understanding who we are talking about. Now, that's not an ideal answer. Lawyers and law in general should look for precision in what it is that they're trying to do. And here we have something which is completely ambiguous because it's an unclear antecedent. That's problem number one. Problem number two is a wider drafting problem. I'm not sure if you can see because of those red circles that I've put on, but you should be able to see just before which there's a comma, which starts the non-defining relative clause, and then there's a comma after end users, which closes that. Now, with non-defining relative clauses, as a general grammar principle, this is where we introduce a clause which is not essential to the sentence. And the effect of that is that it can, in some cases, be largely ignored, because if it's not essential, then we don't have to pay that much attention to it. So if we approach the sentence from that point of view and read the sentence without that non-defining relative clause, then we get this. Operators of a recharging point that are responsible for the management and operation of a recharging point, including in the name and on behalf of a mobility service provider. That suddenly is clear. Here we are talking about the operator. Even if we redraft this into a defining relative clause, which means that we get rid of the which and we replace it with that, and then we get rid of those commas, so now we're saying that everything is of equal importance in that sentence, it would say this: operators of a recharging point that are responsible for the management and operation of a recharging point that provides a recharging service to end users, including in the name and on behalf of a mobility service provider, at least in my opinion, once again is clear. Here we're talking about the operators. If you disagree with my interpretation of this, then two things to take into account. First of all, please, right below the video, let me know what you're thinking if you disagree. Show me how you see the text in a different way. I'd love to have the conversation. And secondly, as I say to the people that I've taught always in the past when I'm teaching plain language, the fact that this can be interpreted in two or maybe more different ways shows that the text has been badly written in the first place. So two things to take into account. So is it really non-essential or non-defining clause that we should be using here? This is a drafting issue in general. Okay. The third issue, now earlier on, if you remember, I was talking about this approach, which I fundamentally disagree with, but nevertheless it exists. And the approach says, if we're dealing with an unclear antecedent, then we take the closest thing to that unclear antecedent and say that it refers to that. So in other words, that would mean that we would understand that this would be the which refers to the recharging point. But if we apply that approach, then does that make logical sense? For example, it would read in this way: recharging point which provides a recharging service to the end users, including in the name and on behalf of the mobility service provider. Can a recharging point, that static thing which allows you to charge a vehicle, can that in itself act in the name and on behalf of a mobility service provider? Probably not. Doesn't make that much logical sense. Whereas an operator definitely could. So here you've got a mismatch between that approach and logic, simply. So in this one sentence, we've managed to identify three separate issues. We've got an unclear antecedent, we've got poor drafting, do we need a defining clause, is it really non-defining, and thirdly we've got this grammar versus logic debate which exists as well. So in short, this is a bit of a disaster. How should we understand this? Well, my best guess, and it's only my best guess, is something like this: operators of a recharging point who are responsible for its management and operation and who provide a recharging service to end users, including in the name and on behalf of a mobility service provider. That's my understanding of how this would practically make sense. But is that correct? I've got no idea at all. That's just how I would interpret that text. An interpretation that I shouldn't have to make if this text followed plain language principles. If it followed point 1.1 up there, that the drafting of a legal act must be clear, easy to understand and unambiguous, which this clearly isn't, simple and concise, avoiding unnecessary elements, which this doesn't, at least may not do, and is precise, leaving no uncertainty in the mind of the reader, where I have nothing but uncertainty in my mind as regards this text. In 1993, as I said, there was that European Council resolution which was passed. In 1995, there was an opinion on that resolution. And it discussed a number of different things. Would it be better to use plain language in official documents? I'm not going to read all of this out. It says yes, it would be better to use plain language, and it makes a very good argument in that text that you can see there. And I would encourage you to pause the video and read through it. And in fact, if you downloaded the PDF, the first link that I pointed you towards, then I think this text is in there as well, this opinion. So it's worth reading that in more detail. So would it be better to use plain language in official documents? The opinion argues yes. The second question is it possible for official documents to be written in plain language? The opinion argues once again, yes, it is. But then it goes on to say it's difficult for officials and others to shed the habit, to no longer do this. That's quite an interesting point. 2.3, is it official policy to use plain language as much as possible? It is. Okay. And it goes on 2.3.3, and here it introduces a criticism. It says, on 8th of June 1993, the Council passed a resolution, which I showed you at the beginning, on the quality of drafting of community legislation with the general objective of making community legislation more accessible. However, the Council did not succeed in drafting that resolution itself in plain language, and the opinion presents two appendixes. A, which is the actual text of the Council resolution, and Appendix B, which is how it should have been written if it was redrafted in plain language. What's the conclusion? This is an interesting conclusion. The Commission should take positive steps to do what the 1993 Council resolution has said ought to be done. The committee has shown that it is an official policy to use plain language. It has shown that it is possible to use plain language in official documents and in legislation. All that is now required is that it should actually happen. The people of Europe are yearning for clear and simple language in European documents. Let us give it to them. That's as true today as it was back in 1995 when this opinion was written, in 1993 when the resolution was passed, and previously. What was missing then, however, I would argue is not missing today, and that is the existence of an international standard, something that I've talked about many times before, the Plain Language Standard, ISO 24495, which sets out the principles on how plain language communication should happen and why it should be followed. This international standard, I think, is the missing piece which now should be guiding how European Union law should be drafted. Let me know what you guys think in the comments below. If you've ever met EU law in whichever form which is confusing, then please leave that in the comments below. I look at the comments. I'm looking forward to engaging with you. So let's start the discussion.